Good afternoon, everyone, and welcome.
Thank you for joining us for today's webinar, Navigating Construction Defects and the Law, Understanding Chapter 558 Claims. We're excited to have you here for what promises to be an informative and practical session.
We're honored to be joined by Paul Overton, CEO of Overton Construction and Consulting, and Kara Olesky of Haber Law, who will be guiding us through the key legal considerations and strategies surrounding Chapter 558 claims. We appreciate your time and participation. Let's get started.
Okay, my name is Paul Overton. The name of our company is Overton Construction and Consulting. And in terms of 558 or construction defect claims, we do a lot of post-litigation repairs. We do expert testimony, we do scope of work creation, sufficiency of settlement analysis, cost of repair, mediation, arbitration support. That's one of the main focal points of our business. We do a lot of consulting, and we work with a lot of boards to get a settlement, and we try to figure out what's the highest and best use for their money. We do a lot of other things, but that's the pertinent information for this course. So without further ado, let me see. I'll share my screen. You guys let me know. There's probably going to be some other people that want to get in. Okay, so navigating construction defects and the law, understanding Chapter 558 claims. Unfortunately, there's a lot of bad building in Florida. The whole state, nothing's immune to it. The big builders, the small builders, it seems like, every time we turn around, they're building a new townhome community and it has, building deficiencies. And typically, the type of deficiencies we see are systematic, so they're community wide. If two windows are leaking on one building, generally speaking, the same contractor installed all the windows, so there's probably issue with all the buildings, but it's part of our industry now. And, in terms of, there's a lot of people that are not litigious, but here's the thing. The silver lining with construction defect claims is eventually you're going to have a big repair project. And, I think this is a way or a path to get some of the money you need to make those repairs other than assessing or coming out of pocket or getting a loan for it. We have the new SV4D and 154 and 913. Like those people, if you compare yourselves or somebody with a construction defect claim, there's a light at the end of the tunnel because you're going to probably get some money, and it's probably going to be a substantial amount. These other people, they're not going to get anything. They get some relief from the legislatures, but they're going to have to come up with that money on ourselves. So me and the people that work in this industry, and including Kara, we do our best to try to help these people get their money and at least have something to work with.
We certainly do.
Kara, would you like to add to that?
Yeah, certainly. So, Chapter 558, for those who are not familiar, is a procedure that provides, the potential for the building owner to file a claim with the contractor or serve a claim with the contractor, developer, subcontractors to get money rather than having to sue them in a lawsuit. I've rarely seen that happen, unfortunately, where you're able to settle the case during the 558 process, but its intention was for settlement. However, in the 558 process, and we'll go through this today, there's various steps that your lawyers need to take on your behalf, that your contractors need to take, that your engineers need to take, and you do that during the 558 process prior to filing the lawsuit.
Very good. I'm trying to let some people. There's a bunch of people that are still kind of filtering in, so excuse the little jerkiness here. Okay, so let's talk about normal maintenance versus construction defect stuff. I think most CAMs and board members understand that you have to power wash your sidewalks and paint your buildings and clean out the gutters and do some sort of roof maintenance. When it comes to building deficiencies or construction defects, we're we're concerned about delaminated stucco, water intrusion through the roofs, balconies that are leaking. You can see some of the pictures here. These are from past projects that we've worked on. And most of these defects here are latent defects, and we'll get into that later. But exterior paintabilities, roof cleaning, gutter cleaning, if you have delaminating stucco, major horizontal vertical cracking, water intrusion through the building envelope, those are really good signs that you probably have building deficiencies or construction defects. And, it's important to know the difference. Is there add to that?
Yeah, certainly I can be brief. So, as most, if you're a licensed manager and you're on this call, you likely know that under Chapter 718 and under your declaration, you have a duty to maintain the building. So that duty never goes away on behalf of the managers. You have, it's typically outsourced to the management company, and they hold the responsibility for the association to maintain the building. But items that can't be repaired through normal maintenance, there's, what Paul has put on his screen and what Paul has discussed is cracked stucco, delaminating stucco. If you have water coming into your building, that's not going to get repaired with regular maintenance. That likely wasn't caused by, failure to maintain. That was caused by something during the construction. So, and that would be the time where you would want to call your professionals, as I like to say.
Yeah, get the team together. Yeah, and I think, one thing that I want to point out at this juncture is, if you suspect construction defects or building deficiencies and you're concerned that, you may have a major project or latent defects, the ones that are hidden, just call a professional. Most professionals are going to come out there nowadays. I know myself, and there's engineers and other people that specialize in this industry. They'll come out there and they'll usually do a free consultation. And, after doing many of these, we generally have a pretty good idea if we're looking at a construction defect claim or, it's something more along the lines of maintenance. But again, call somebody, and we're going to get into statutes, the timelines and statute of limitations and repose. That stuff has changed, and it's not as good for us now as it used to be. So we're going to talk about the timelines as well. Florida's construction defect statute. You want to take this slide?
Sure. So I did touch on this a little bit on the first slide. So we could probably move through this one quickly, but Chapter 558 is a creature of statute. It's a Florida statute. It's, what we file and what we focus on when we have a construction or design defect. And, if you're interested in having your property checked out, whether it's exactly post turnover or, and this is something a lot of people don't realize, 558 applies to every construction project unless you waive it in a contract. So it applies at turnover, and then it'll apply to your concrete restoration, or if you build a pool, or if you rebuild your pool, or if you do any work at your property. Once the job is complete or reaches substantial completion, then you have to follow Chapter 558. And that means you have to file the notice requirements, you have to allow inspections, you have to allow all these people into your building to let them observe the defects. And so construction deficiency, refers to defective materials, defective construction. Design defects is the designer's failure to, apply their standards or design in accordance with their professional standards, or they have a code violation in their plans. So defects are much more significant, or can be much more significant than, just your regular maintenance at your building. And the defect, if you're going to pursue a defect case, you need to, hire your lawyer, hire your engineers, have a contractor come out and look at the property, do the pricing. You really have to cover yourself from all ends when pursuing a Chapter 558 case.
And I think you touched on something very important. The statute starts over. If you have a major renovation project, you have another essentially we'll call it 4 or 7 years to file a claim. I've ran into a lot of people. They've, they've called me out and they're like, "Hey, we want to bid for this." I'm like, "Who did this work? It's really bad." And they're like, "Well, we hired somebody, they did a good job, and the building's still leaking, and we need to get them fixed." And so, you can file a claim at that point. You effectively reset the clock.
Yes.
Um,
Anyone that
That's a
does,
limitation. Go ahead.
anyone that does work on your building, when they're doing a construction project, or your house, if there's an issue, you have a claim against them and you have to go through the 558 process. It's not only at turnover.
I touched on this a little bit. Typically, the people or the contractors that specialize in this, they serve as expert witnesses. They may give depositions on costs. They create expert reports, usually generated from destructive testing. The company will likely do destructive testing. They will create scopes of work. At some point, you're going to get to a juncture in the claim where perhaps the plaintiff's expert has said, "Hey, this is a $10 million job." The defense says it's $3 million, and they may call an expert in to say, "Hey, I think real world numbers, this could be a $7 million job." So there's all kinds of steps along the way where a general contractor or consulting expert may be able to help. And then, of course, once they get their money, they do the remediation. Typically, they have cool subcontractors that they can pull from. They create bid matrices and help interview the contractors. And I guess one of the new things that it's kind of new to really, I think, Central Florida and other parts of Florida, but in South Florida, the owner's rep is becoming very, very, very important and very, very popular. And I think there's a couple reasons. Number one, the jobs are very big. They're very complex, and a lot of associations, let's face it. At the end of the day, managers aren't construction defect experts or construction experts, and neither are the board members. So, I think it's a really good play to at least consider, maybe an owner's rep, and maybe they take the place of a general contractor. I know the two are kind of interchangeable for me. If, you hire the owner's rep, he can get bids too. So it's really up to you and the level of risk that you feel comfortable with. But I think we're going to start seeing it more in Central Florida and other areas of Florida besides South Florida. Okay, this one's yours. What do we need to look for in an attorney?
So
And knows what they're doing, right?
and when do we call the attorney? When do we get the attorney involved? I think that's also important. So if many managers are familiar, you have turnover of your property, you hire new counsel. That new counsel, if they're a condo firm, and also as managers who know this at this point, I believe, you find a construction firm that also has condominium knowledge, because you want someone that understands your condominium declaration, that understands Chapter 718, and if we have any Chapter 720s on here as well, that understand masters associations, and also understands how the construction chapters and statutes, how that affects Chapter 718. So you definitely want a firm that understands both, like Haber Law. But you want to, and when you're talking to your lawyers, you want to make sure they have a strong understanding of the construction knowledge and the process, that they have experience litigating these claims in the state of Florida, that they understand the insurance policies that are in play, because that affects how much money you can ultimately get back at the day. What do those insurance policies say? What are the exclusions? You want someone with knowledge, and really knows this area of the law. You want someone that is able to, eventually depose your developers, your general contractors, your subcontractors. We're going to be taking their depositions. Do you understand their terminology? Do the lawyers understand their terminology? Do the lawyers have relationships with these engineering firms, and they know who these reputable engineering firms? You want to make sure that you're retaining a licensed engineer to act as your expert, that you have a licensed architect to also act as your expert, that you have a licensed general contractor to act as your expert. You want to make sure that your lawyers are familiar with this and understand this. And that can definitely be hard if you've never gone through the 558 process before. So you certainly want to be, communicating with either your regionals or your vice presidents. If this is your first time going through a construction project, you want to make sure you're absorbing that knowledge, and because you don't know what you don't know. So you certainly want to reach out to a law firm that has all the experience I suggested, reach out to these engineering firms that, have done this 558 work, and these general contracting firms such as Paul's that have done this work before and they understand how it goes. Because it's going to be very, very difficult for general contractor firms when they're doing destructive testing if they've never done it before. It's completely foreign. You want a general contracting company that understands that the defense is going to get a spot on that swing stage. So you just, you feel them out. Everyone has to use their best judgment, and you just, you have to talk to them and make sure they, you got to believe that they know what they're talking about.
There's been instances in the past where I've got involved in a construction defect claim where the attorney was somebody I had never even heard of, and it in each instance, it never ended well, typically if they're a small guy, which, may or may not be a problem, but, if they're taking it on a contingency or some kind of hybrid model, they're trying to sell that case. They're trying to get you some money and get their portion and move on down the road. So you want a large firm that has leverage, that has dealt with these, the defense attorneys before. Because I can tell you right now, if you hire an attorney and the defense is not worried about it, you're in trouble. If they see Haber coming in the front door, they're like, oh, okay, we gotta play serious. We gotta get our stuff together. We're gonna have to pony up some money. It makes a big difference. It really does. So, all those things considered, just make sure you're doing your due diligence.
Certainly. And you also want to be comfortable with your lawyer. You have to like them. I mean, you're going to be talking to your lawyer a lot. So, you do want to like them. And I practice in construction, I practice in condo law. I don't practice in personal injury. That's just not, that's not my area of the law. I'm unfamiliar with it. I would refer that out. So you want people, you want to feel confident that your lawyers know what they're talking about. So moving on to statute of limitations. So the statute of limitations hasn't changed in Florida. You have 4 years from when you discover the defect. So that's subject to the 7-year statute of repose. So statute of limitations, let's say you're a condo association, you have 4 years either from the date of discovery of the defect or the date on which it should have been discovered with reasonable diligence. So,
there you go. I muted.
So you have your statute of limitations that's subject to your statute of repose. So let's just talk about turnover. If there's a gap in your stucco, like a huge crack, the statute of repose is told until under 718-204. The statute of repose does not start until turnover. So you basically have 7 years from the date of turnover to bring your construction defect lawsuit. And you would have 4 years from the date you see that crack. So if the crack's present at the time of turnover, you have 4 years from that date to sue the developer, general contractor, subcontractors, designers for that specific construction defect. And you really want to do it all at once. You want to get your law firm in, you want to get your engineers in, you want your engineers to do a top-down inspection, you want them to go find the latent defects, because when you bring this lawsuit, you don't want to do it multiple times. You want to, open up some walls if there's reason to do so. You want to see what's going on. You want to check the entire building, because what these defense firms, these experienced defense firms, they really, just like the plaintiff side has experienced lawyers on this side, there are defense firms that are very experienced in this, and they know what they're doing. And so they're going to, at the end of your lawsuit, they're going to want you, the association, to release every single claim, patent defects, latent defects. So if you did that investigation on the front end and you continue investigating the building and you do your destructive testing, you should uncover all of that so that it's just done in one lawsuit. But 718-204, very important statute for condo associations. That was changed, I think, in the 2024 from what had been changed in 2023. But you don't have to worry about the statute of repose. It's told until turnover. You have 7 years from turnover. That's the law as it stands today. But that's also ever changing. So you have to pay attention to, what's going on.
Yeah, well, they told us 7 years was a good compromise from 10.
Right. But before that, it was
Builders and developers wanted less. We were at 10. They said 7's fair. Well, it used to be 15. So I don't want you to tell me if this is fair.
and seven.
By the way,
Seven is tight.
by the way, I'm sorry, go ahead.
7 is tight. That is not a lot of time.
Well, the issue with 7 years for me is a lot of the building, especially the latent defects, they haven't manifested themselves yet. So like you could have a building riddled with rotten framing and stuff and really not know it. Maybe the stucco's still hanging by a thread and it's not cracked and delaminating because, it's attached to rotten studs, but it will be. By the 10-year mark, usually everything's manifested itself. You have a really good idea if you have a claim or not. But 7 years is very, very tight. Eric, 4 years. Yeah, and 4 years is very tight as well. The example I always use is, after turnover, if you are having roof leaks, right? And then you have a paper trail and there's emails and you're having contractors come out and fix stuff. And you know about these roof leaks and you didn't do anything about it, then you can be barred from, you can still file a claim, right? But you may not get no money for the roofs because you didn't file it within 4 years. So I'm wary. There's 2 separate issues here, 2 timelines, and the clock is ticking. And they're trying to take them away from us, but maybe we get some back in the next couple of years. Who knows? Statute of limitations. Go ahead.
So it's just a little more detail of what we were just discussing. So it sets a time after an injury or damage occurs, and that's all across all areas of law. With construction and design defects, you have 4 years. So I know we've talked about turnover. Let's talk about a concrete restoration project. So let's say, your building is now somewhere in the 12 to 20-year-old range. You're doing your first major concrete restoration project. The project goes according to plan. Everything's on schedule. 1 year later, stucco cracks start happening. Water starts getting in somewhere. The cracks start getting bigger. What is who can you sue? What is the focus? What is the trigger date? I would argue the trigger date is when the cracks started appearing and you started seeing it. The defense would argue, well, it happened when they were done when the contract was, when the work was completed, because the injury had already occurred and that's when it was manifested. And it was manifesting at least a year prior. So you never want to wait. Don't wait till 3.5 years after you first see the crack. Don't hold on. Get your lawyer, get your engineer, start evaluating, start seeing what's going on. There might be a huge issue that you're completely unaware of, and you don't want to be up against that 4-year deadline. You don't. It's always best to get your investigation done. So write your recommendation to the board. Dear board, we're starting to see issues with the stucco. We should probably engage an attorney. Maybe your general counsel has construction attorneys. If they don't, you need to get a construction attorney, and you need to get an engineering company out there, start investigating and looking at what's going on.
Yeah, absolutely. And there's been many times in the past where we've been called out and the manager she wants to get the buildings, or he or she wants to get the buildings painted, right? And we come back and listen, we get it. Construction defect claims and the whole entire process is onerous, right? It takes a long time. There's paperwork, but ultimately it's in all likelihood the best path if they truly do have construction defects to take that path, because you're going to get money. And a lot of managers, or I guess some managers, they don't want to get involved in the litigation. It's a lot of work. Some people are like, hey, I don't want to put my board through this. And, they paint the cracks. They call them paint. And we've been called out many times and we're like, hey, you have defects. And so, we get it. We understand why those decisions are made. But again, somewhere down the line, you have to pay the piper. And it's either you get the money from people that caused the problem, or you're going to have to get a loan and assess the community.
That's right. And, if in that instance, when, a manager does call a company like Paul's going to say, hey, we paint this. You might be painting over some bigger issue. You may not want to paint it. And that's the great thing about having a general contractor that has experience in the 558s, because he's going to be your second line of defense. They're saying, hey, you may not want to do this. You may want to alert your board. And that actually happened. That happened in one of our buildings. We had a client that was approaching, this is back when it was the 10-year statute of repose. The client was approaching that 10-year. They were doing a paint project. The painters got up on the swing stages, start getting ready to paint, and they could see the post-tension cable pockets. And they said, absolutely not. We cannot take this on. We can't buy this defect. There is a real installation problem here, board. You need to look at this. And our client got very lucky. They had hired, they had just gone right to hiring the painting sub. I don't think they hired a law firm at first. They didn't investigate it with an engineering company. They didn't go through their 558. The painting company saw it. Then they got counsel, and we were able to, handle it. But you have to move very quickly when you're approaching that now 7 years. Had this happened to our client in the current time frame, they would have been out of luck. And they had a huge post-tension cable issue at the building that was caused by original construction. So you want to make sure you're also hiring experienced general contractors and contractors when they're doing your work at the building. It's very important.
Yeah, experienced and ethical too, because, I can see a situation where a contractor gets awarded a job. He wants to do the job. He wants to bill. He wants to get the revenue. And what essentially they should do is say, hey, there's a problem here. We need to shut this job down. We need to have the engineer come out here and look at it. And, we need to inform the board. It's probably not a good idea to paint this or whatever the scope may be. There was a project where there's been several, but I can remember one where we got called out to do a paint walk by one of the major paint companies. And they wanted us to paint a building. It turned out it was 126 8-unit townhomes. And so we were excited about going to this walk and doing some stucco repairs and painting. And it turned out during the course of the walk, I could tell there was stucco issues, and it turned into one of the biggest construction defect claims in Phoenix history. And we were awarded bank lead for helping them identify it. But, it can happen. So you got to be diligent. You got to be on the lookout. And
I think that was a really strong word, ethical. You really want to hire ethical people that are going to do best for you and best for you, the client. That's very, very important.
yeah. So 2 types of defects. We have the patent defects. Those are ones you can see. You can see your stucco's cracked. There's some spalling concrete. Maybe you can see some rusted rebar through the spalling concrete. And those are, the type of ones that would probably the statute of limitations, the 4-year statute would probably apply to. But then you have the ones that are the latent defects, and they're like cancer. They're the ones going on underneath the concrete, underneath the wood, roof sheeting, the window flashing details that you can't see. A lot of examples of latent defects. And I guess primarily for me, those would be more under the 7-year statute because you're not going to be able to see them. But again, I always tell people, look, you got 4 years. Okay. You got 4 years. Get your building inspected. Don't bank on the fact that you can wait 6.5 years and then have somebody come out and inspect it and file a claim and get all the items in the claim. So can you hear me, Cara?
I think we lost you for a second. I don't know if it was just me. I can hear you now.
I got a thing on my screen that says my internet's unstable.
You probably want to say what you said for the last 45 seconds. I think we missed it.
Okay.
Or do you remember?
Applicated defects, and primarily those are the ones that you can see. You can see the stucco's cracked. You can see, the falling concrete, maybe some rebar. And those are typically would be considered maybe the 4-year statute of limitations stuff because you can see them. You need to file before the 4 years is up. You should have known, or with due diligence, you should have known. Late defects, those are like cancer. Those are the ones going on underneath the concrete, behind the siding, behind the stucco, roof sheeting, window flashing details, that sort of thing. And those, for me anyway, when I look at it, those are probably defects that you're not going to notice right away. There's people out there that have gotten really good at inspecting these buildings and can see telltale signs, but like we use infrared imaging and and other stuff to see through stuff. So typically you're not going to see them. And so what I usually tell people is when there's turnover, I tell them you have 4 years. You have 4 years to figure out where the latent defects are, where the patent defects are, because if you miss, if 4 years runs and, you could be barred from making some of the claims and doing it all at once, as Carl suggested. So we used to have a Jeopardy game at the end of this presentation, and that was one of the questions.
That would have been good next time, Paul. If you invite me back.
Love the wheel. Maybe the Wheel of Fortune. Okay, but some more defects, some examples: debonded stucco, concrete repairs, corroded rebar, elevated pool leaks. I've never seen a pool that was elevated that did not leak. So make sure you're keeping an eye out for that. Broken PT cables. You can hear them break and they're loud. It sounds like lightning hits your building. But if they're broken and previously and nobody knows it, that's a major issue. That's what's basically supporting your cantilever concrete slabs. Rotten framing members, roofs, sliding glass doors. A lot of issues with sliding glass doors. Almost every project they have, bad flashing detail. I guess it would be windows and door, or windows, sliding glass doors and windows both. I've never seen a window flash properly yet, especially on a townhome community, or a sliding glass door installed right. Sinking pavers, those are always tough. We try to get money for that. We try to get in the claims. Sometimes it's successful, sometimes it's not. We live in Florida. We live on a swamp, and they put the pavers on a swamp. They're gonna eventually sink and probably settle. So those are the. Do you recognize this one?
This building?
I think that's Essex Towers.
Oh, I think you're right. That one's not mine. That
I
one.
think that's Essex Towers. Okay, interim solutions versus permanent repairs. This happens a lot, believe it or not. Somebody calls us. Hey, we have roof leaks. We need this one building painted. It's leaking. We need you to come replace the windows, whatever. We go out there, we ask questions, we find that there's a construction defect claim filed. Okay. So Cara can expand on this and tell you all the reasons why it's a bad idea to cover up the defects with paint and replace stuff. There's nothing good can come of it. Okay. So I guess the main point I always want to get across is, listen, if you have an issue, you have the right to remediate it. Okay. But there's a protocol. You got to work with your attorney. They got to notify the defense. They got to get everything. They have to sign off on it. You can't just get on the phone and start calling contractors and expect, when down the road that it's going to be okay. So many claims have been derailed that I've been involved with because the board or the manager, they just didn't know that there was a protocol around doing, repairs, whether they're emergency repairs or something, water intrusion. So, you do have the right to remediate, and probably Carl has something to say about this as well.
Certainly. So under Chapter 718, you have a duty to maintain your building. Under your condo declaration, you have a duty to maintain your building. And under 558, it permits for emergency repairs. But there is a difference between an emergency repair, like concrete's about to fall off the building, we need to get up there and shore it or take it down, and the paint's, kind of peeling and it's speckled. I would never advise a client to just paint it and cover it up and move on. You don't want to spoliate any evidence. So let's say you have a true emergency repair and you need to get it fixed. You need your engineer, you need your licensed contractor to do that repair, and you must document it. Document it. Take photos, take videos of the before conditions, of the during the construction, of after the construction. Take photographs. If you can, sometimes in emergency situations, the lawyer gets the last call. That happens more often than people think. I would love to be the first call, but it doesn't always happen. It's not always the case. What you need to notify your attorney so that your attorney can send a notice of claim out to if it's the initial turnover, to the developer, the GC, the architect, the structural engineer, and all the subcontractors. You want them to get that notice out the door. They're going to invite everyone to come and look at what's going on. But the association, if it's a true emergency repair, has a duty to make those repairs. You owe a duty to your unit owners, to the guests and invitees. You need to make sure the building is being maintained. So if it's a true emergency, you can go ahead and repair it, but subject to everything we just discussed. Document it, engage in licensed professionals, let your attorneys know so that they can get that emergency notice out. Sometimes things happen where the emergency notice doesn't go out for 48 hours and the repair has already been made. That's why it's so important to document everything. You don't want to spoliate evidence. That means like destroy evidence. You never want to do that, because eventually, in order to get this money back, you're going to have to prepare and go or go for trial if you can't get your case settled. You can only get your case settled if you have all of your ducks in a row. You need to have everything lined up, all of your evidence, all of your support, your testimony from, all of the licensed professionals. But you can only do that if you follow all the steps. So it's very nuanced, and you have to be careful, and you have to really think like, okay, am I going to destroy evidence that I need to present to a jury? And that's obviously not a natural way for people to think. If it's an emergency repair and it needs to get done immediately, document it. Everyone's doing the best they can. You may face some spoliation charge later down the line, which is why it's so important and in addition, any materials that you remove, keep those materials. Don't let the contractor throw it away. Keep them. Put them in storage. Have your contractor or your engineer store it for you off-site, store it on-site. Don't get rid of it. That's just the best practice. It's not always practical, but that's what I would advise. And, you go about making your repairs eventually to the remainder of the building.
Very good. All right, destructive testing. What is destructive testing? So typically after the claim is filed, the attorneys and, probably the board and the association, everybody involved, is going to want the engineers to come in and do a thorough investigation of the building or buildings. And usually what that means is, depending on what region you're in, South Florida, there's a statistician involved. It's a little more complex. They have to pick the locations, which makes it even more troublesome, especially when you have to rig the building with swing stages just to access the areas. Other times when there's not a statistician involved, the engineer can pick the locations. And generally speaking, let's say you have your typical wood on block townhome community. There's 30 buildings and they're all sixplexes. Typically, they're going to do 20 roof openings, maybe 10 roof to wall openings. They're going to water test 5 to 10 windows, maybe a couple sliding glass doors. They're going to open stucco. Maybe there's 15 or 20 stucco cuts that they make. Typically, those are going to be at the bottom of a window so they can check the flashing details of the window at the same time. And then usually that's about it. In South Florida, you have all that plus expansion joints, waterproofing, pavers, tile, elevated pool decks. It gets pretty complex. Usually in Central Florida, it's very common to have a 2 or 3 day DT. And in South Florida, it's pretty common to have a 6-week DT. We just finished one. So I think the major reason is just number one is access. You have to get with Swing Stage Company. You got to find out where the statistician wants all these openings made. You have to get the engineers to those. You have to get the defense attorneys to those so they can witness it and document it. And then ultimately, you need to get the subcontractors or your guys there to put everything back together. So it's a long process. Usually, this is performed by a licensed architect or engineer, and they have a general contractor that works with them to help them, with the labor, the cutting of the buildings. Typically, the engineer or the architect is going to be doing the documenting, kind of just pointing and showing the guys where he wants cut. But really, it's just a very thorough investigation. They don't fix or they don't cut into all the buildings. A lot of people ask, well, how do we know if you found all the damage? Well, we don't 100%, but we're allowed to extrapolate. So if we make 20 stucco cuts and we find out in every one the first coat of stucco wasn't embedded to the last, we can extrapolate that to the rest of the buildings. That's kind of how it works. So it's just a matter of getting enough evidence to be able to extrapolate with. Sometimes we got to go back and do 2 GTs. Maybe it wasn't conclusive enough. Maybe we didn't test enough windows or doors, or there was, a fail rate that wasn't, what we were asking for. There's all kinds of reasons you could go back, but that's really kind of it in a nutshell. And once the destructive testing is done, the engineer will issue a report, and I call those, a lot of people call them the expert reports. And that's really kind of the first milestone in a 558 claim for me anyways, is, hey, look, we did our investigation. Here are the issues. Here's what needs to be fixed. And typically, they may give that to somebody like me that does a cost of repair or something. But really, that's the milestone. That'll tell you what's wrong with your buildings, where they failed, where they didn't, and, probably some sort of scope of work. Most of the engineers, architects, or turnkey GCs that do this, they're going to come up with some sort of scope. And scope they come up with is definitely not going to be agreed on by the defense, but it's a good starting point.
Certainly. And I think you hit that right. That's the expert report is the milestone. That's the first one. That's what are we dealing with here? How pervasive are the stucco issues? How pervasive are the post-tension cable issues? Whatever the balcony railing issues, that is when we find out how present everything is. And then when you get that expert report, you hand the expert report and the quantities of all the defects over to a company such as Paul's, a general contracting company, to price out the work. This is what it's going to cost the association to repair. And then the association has their damages number. That's when, they know what they're working with. They understand what their trial number is going to be. You understand what the maximum issues with your building are going to be. And that's the number you're going to go and pursue most likely in front of a jury. 558 cases are jury trials, subject to some other limitations. But for the most part, condominium turnover Chapter 558 cases are jury trials. And, you have to go plead your case in front of the jury. So how much disruptive testing did you do? Like Paul said, and I primarily practice in the greater South Florida area. We're going to hire a statistician who's going to tell everyone where to test, pinpoint the locations on the building, so that the engineer can arrive at an opinion of, okay, this is how many square feet need to be repaired. This is how many linear feet need to be repaired. And the statistician provides that random sampleization for the association so that they can feel confident in what they tested applying to the entirety of the building, rather than opening, 10,000 PT pockets to determine how many of the post-tension cable pockets are defective. I mean, you would be repairing the entirety of the building at that point. That could take 8 to 12 months. Paul, how long could that take? That would take forever.
Well, if you're going to spend your settlement money before you get it, how about that?
Right. Destructive testing is expensive. And that's something that, you really have to explain at the start of your 558 to a board, to your client, that, hey, you're going to need to spend all this money before you even start repairing. We have to spend money to investigate what's wrong. And, that's a tricky conversation. And you want to have experienced professionals that can, do this efficiently and cost effectively and know what they're doing and, get to the building, get to work and know what they're looking for in the realm of destructive testing, because it's very different than just a typical repair project.
Yeah, I think the experience, you always have to hire somebody that, especially, I guess, South Florida region is probably, it's almost, I guess, impossible not to hire somebody with experience. Did my screen just go dead?
Nope.
Yeah.
Oh, you can't see it?
No.
Oh, it's still the what destructive testing. What is it slide? So I can see.
My screen went completely dead. So anyways, yeah, you gotta hire somebody with experience, because like Carr said, destructive testing is very expensive. Typically engineers, I know guys that are charging $525 an hour to be on site doing destructive testing. It's a lot of money. If you don't have a contractor that's competent and can't get the swing stages where they need to be, can't get the windows isolated, get the spray racks up there, that sort of thing, sequence, get unit access, put production down, all these things that you need to do in destructive testing, you're wasting money, and the engineers get aggravated, the unit owners get aggravated. And then, you have to worry about the putback. We just did one and we cut 262 holes in the building. That's a lot of holes. We had to go back and we got to patch them, and the people got to live like that for 2 years, right? So they got to look good. So you need to make sure that, you have somebody. This is weird, card. I cannot see my screen.
All right, Paul. How are we doing?
Yeah, I don't know what my screen is completely blank. I can't see anything on there. I can't click any buttons. I can't extend my displays. I can't stop sharing. Can't do anything.
Okay.
So I usually want to answer the owner's rep and general contractor. I think the question was, what's the difference?
Mm-hmm.
So the difference for me is, because we do both, is in one role, I don't have to finance the job. Okay. Owner's rep, you have less liability. You don't have to finance the job. GC, you have all the liability, and now you're financing their job for them as well. Plus, if you are the general contractor, the relationship with the board and the management can be a little, I don't want to say sketchy, but just, everybody's is on a high alert. When you're the owner's rep, you have that relationship with the board and the manager. You're their liaison, you're working for them. But at the end of the day, it's really the same work. I mean, for years before the owner's rep came along, we were creating construction schedules, getting the subcontractor bids, creating the scopes of work, managing the job, improving payouts. I mean, everything that I've been doing for 20 years, now they have a new name for it. It's called owner's rep. So if they want to pay me as an owner's rep and I have a better relationship, yes, I make my money, but that's a more comfortable role for me, and so I guess that's my perspective. I can't see the screen. So here, what I'm going to do is I'm going to try to go over to here. Now you see can you see the screen?
Yep. I see you.
What's the next slide? You're just going to have to.
Yeah. So the next slide is, what's behind the walls.
Oh, yes.
I know, it's that great picture of all the framing.
Okay. Yeah, that's actually a project we worked on. So those are, the latent defects. That's the framing, sheeting. I think this particular picture is actually a job that we did in Kissimmee. And those walls were actually missed during the investigation, the destructive testing. Nobody thought to test there. And it wasn't really nobody's fault. They got overlooked. And we got awarded the job, and we found out that there was a little dead cricket up at the roof, kind of where it meant the stucco, and the water just sat there and it matriculated down and it kind of just ruined that whole elevation. And fortunately, we found it because what's holding up that wall is a beam sitting on 2 metal brackets in the wall, and it was all rotten. So again, just another illustration of latent defects. And, it's hard to see them. The professionals miss this one, right? So I don't think there's a high expectation that a property manager or a board member or a resident could actually find these.
Right. So, Paul, I'm not able to share my screen, just so you know, but we can still, I think there's just a couple pages left. The next one is the inside the concrete. If you want to talk about.
I just made you the host. See what you can do.
Oh, okay.
There you go.
All righty. So this was the wall Paul was just referring to. No one tested that, and then look at everything. That's why you want to make sure, that your professionals are on top of it and looking at everything. You don't want them to leave anything out, because that's how many townhomes had this condition, Paul?
Well, there was 32 locations just like that one.
That's a lot of money to miss.
We had to build false walls on the inside of that, demo everything, framing, insulation, drywall, everything came out. Basically, we put a big hole in the wall building, and 32 locations.
Yeah, that's a lot of money to leave out in your case. So you just want to make sure, you hire these professionals, but at the end of the day, this is it's the association's case. And so there's a level of collaboration that's required between your manager and your board, your manager and your attorneys, your managers and your engineers. There's a lot of working together. It's a huge undertaking. And you just want to make, you're a part of it as well. And you're much a part of it as you make yourself. And you just want to make sure that coordination and that you're reporting these issues to your contractors and engineers and to your lawyer so that someone's making sure it gets checked and gets included in your lawsuit. All right, next is inside the concrete.
Yes, we have some exposed rebar, corroded rebar. It's a pretty simple process. The salt water gets in there, the rebar. Typically, that happens because the concrete's not waterproof. And Carr knows this. They just don't waterproof buildings right anymore. They put it on a roll-on surface, and guess what?
Why we have
tires down the road, your concrete's chipping off because water's gotten in there. The salt chlorides are attacking the metal. It swells, and then we call that spalling, where it chips off the concrete. And I guess differently from Central Florida and a lot of Tampa, and especially Jacksonville, they don't have a lot of reinforced concrete. But when you're dealing with reinforced concrete, it's big money. It's it's way higher square foot replacement cost than typical stucco or siding. A lot of these repairs, like that middle one, what you literally have to do is you have to go in there and you have to chip out all around that rebar, all the way so you can literally put your hand around it, behind it. And then you have to cut out the bad, and then you have to tie in new rebar, or the engineer, depending on the engineer and what the process is, overhead, vertical, or horizontal slab, they're very extensive. And you got to patch them with several different things. And, it's not just a matter of cutting out some stucco and patching it in there. So again, it's, I guess, on the front end, if they waterproof the buildings right, I think that's really probably the biggest issue. But again, we live in a salt air environment, and it's really that salt water in the air, it attacks stuff. And one of them is steel and rebar. So, you got to be very diligent, make sure that you're keeping up the maintenance on your buildings and that you're keeping the waterproofing up. And Carl will tell you this. The first thing the defense is going to say is you didn't take care of your buildings. You didn't provide enough maintenance. Hey, look, and if you didn't, it can be a problem, right? If you didn't waterproof your stuff, or you didn't paint your building, or you didn't, take care of stuff, then yeah, it could be an issue. And now you're asking the defense to pay for something that you were negligent on. Usually that's not the case. Usually it's pretty clear cut sign of construction defects, but that can be an issue.
Right. It's less of an issue when on that turnover lawsuit, because the developer is in control of the building. The developer is responsible for everything up until turnover. And then if you get going really quickly with your 558 investigation, you're maintaining typically during that time. You're not missing it. The issue arises if it's, you're at that 6th year and you've done no maintenance on your building. You're going to have an issue with the breach of the building code violation cause of action. You're going to have perhaps comparative negligence when you sue for negligence. You want to maintain. You're required to maintain. You should maintain. Follow those O&M manuals that you get at turnover. They have important information in there. Make sure you have your roofer coming out so that you maintain that warranty. Make sure you're taking care of the exterior of the building, the windows, have a maintenance schedule, things like that. You don't want to fall behind on that stuff. Not only for the litigation, but also for the health of the building. So this is a nice little who to call in case anyone missed the beginning. Paul Overton, CEO and founder of Overton Construction and Consulting. And I'm Kara Olesky, and I am a partner at Haber Law. And you want to make sure that you talk to qualified construction companies, you want to talk to qualified attorneys, and you want to talk to qualified, engineers as well. And then our last slide is the recap of the steps in the 558 process. So first thing you do after that turnover meeting, get get your bearings straight. If you're, new management coming in, take stock of all of the records that you have that you receive from the developer, make sure you're not missing anything. And then it's time to start consulting with your professionals. The developer should, in a condo association, should provide you with their own turnover report. Typically, that turnover report identifies some issues in the construction of the building. It typically points out some defects. So you're going to want to start paying attention to those. You're going to want to hand that report to your professionals, and you're going to want your professionals to start looking into the building. What's going on? What doesn't look right? What doesn't match the plans? Why is there cracking? Why is there water intrusion? Next step, your attorneys are going to serve the Chapter 558 notice just to protect yourself and to protect the association. Probably should get it served out on everyone, to the developer, the general contractor, architect, engineers, subs if you know them. You should at turnover receive the developer's project file. There should be records in there, so you should be able to identify who worked on the property. You should be able to identify, and when I say you, I mean your attorneys. They should be able to identify whose scopes of work are implicated, and get that 558 notice out and start, investigating. You probably, in today's, with the changes in the rules of civil procedure, when you're in a lawsuit now, you have to move a lot faster. So a lot more destructive testing is actually getting performed prior to filing a lawsuit. So it's very difficult. How do you explain to your board? You got to spend all this money before you even file a lawsuit, because once your lawsuit's filed, that court's going to set a case management conference. You're going to have a case management deadline. You're going to have that expert report deadline. Remember that milestone we talked about earlier? And you have to have everything done by then. And these judges are not moving these deadlines. So you're probably going to have to start your real destructive investigation prior to getting that lawsuit filed. You want to get your lawsuit filed on time within that 4 years. You do not want to wait past that 4 years. Sometimes you want to file within 3 years so that there's no issue with the warranty claim. But that is, more of an individual basis, but definitely don't wait past that 4 years. Then you get your expert disclosures. You get that cost of repair from that contractor. And then you start, depositions, mediations, all the stuff that everyone knows from trial. If you can settle, that's great. And if not, make sure that lawyer that you hired is prepared to take this case all the way to trial. Because you want what's best for your building, and you want to be able to do as much as you can. So it's a great way to stay organized, to stay on track with these case management orders, because, your lawyers now there's not going to be any extensions anymore. Florida's getting rid of, extending trial, extending deadlines. We've adopted new rules of civil procedure that started this year. It's very difficult to get those trial extensions, and your board doesn't really want them. They really want this resolved. They want, their day in court, so to speak, as soon as possible. Then once hopefully you collect a settlement or you get a jury award, you start those repair projects. And kind of as we discussed today, you reach out to a general contractor to get pricing. Maybe you need an owner's rep to assist with the coordination between the general contractor and the engineers and all the repairs that you're doing. There's a lot to it. The 558 happens, and then after the 558, you have to repair. You owe, the board members owe fiduciary duties to their unit owners. They have to do these repairs. They have to, they have to make sure that this money is put to work. So, that's a whole process, which we barely talked about today. And now, we could talk about that, Paul, we could probably talk about that for 5 years.
Well, if I had a dime for every time the board didn't spend the money, I would be rich.
Right. There's just a lot more to it. So I took the slides down, because that last slide was I didn't have the updated version, but, then you want to start reconstruction, and you want to start those repairs. So this is usually when we go for question and answers, and I see we have a few more questions. Or Paul, do you have something you want to add to that wrap?
I think you touched on something. I think it was the second to last slide, but you need to have a good team. And I guess something that I always consider is, are you hiring an attorney that can take this to trial and win, prepare and get it done for you in trial? Because if you don't, the defense knows that too. and it's going to be a long, drawn out process. You're not going to get the money that you need, and people will come in with lower fees, hybrid whatever it is to sell and begin a construction defect litigation case. But if you're not hiring the right people, you're going to have problems. And I see it on the back end. I see this attorney gets 3 million, this one gets 6. And that's really the difference of having a successful project. Like a lot of times, and my team knows this, I've been brought in, they're like, okay, well, this is how much we have. I'm like, I can't do anything with that. Like, why did you hire that person? And not to like throw any of my butts, because I'm just saying.
No, let's not do that.
That really happens. And I've been in that situation in the past, and it's not a good place for anybody to be. You need those monies, and you have to understand too, typically if you're on some sort of contingency, you still have to pay your fees, and then you have to pay the experts and stuff. So you need to factor all that in. And it really, that's probably a time when you do a settlement analysis to see what you really can do with that money. But your attorneys, the good ones, will direct you in the right direction. And, they're willing to take a trial for you if they're not willing to come to the table and give you a good offer.
Right. And I think that's important. What is this work going to cost when we go to do it? And that's guided by your expert opinion. That is guided by that cost of repair. So, everyone has to, the board has a business judgment rule protection, but you want to do good. And especially as an attorney for these buildings, you want to do good for these buildings. You want to get them what they need to make these repairs. So it's a huge process. I think we've scratched the surface. I think we went in, but there's so much more that Paul, and I could go on. We can be here all day. I don't know if anyone has any other questions. Just, if the takeaway from this is just make sure you hire your professionals, make sure, you're consulting, don't make the decisions all on your own. That's a lot of pressure on you as well. A lot.
So if you got any questions, put them in the chat. More than happy to.
Paul, are you going to make this presentation? I think some individuals would like it. I'm okay with it. I don't know.
Yeah, we record it. I think Lori's going to put it on YouTube. We'll send you the link, and I think she's going to put it on a YouTube channel, and I think we're also going to put it on LinkedIn. Are you talking about the PowerPoint or the recording?
I think they want the PowerPoint. That's what I'm seeing. I believe the attendees want the PowerPoint.
Yeah, I'm okay with that.
Okay, great.
Just email us. Again, if you are a manager and you want credit, and you want your certificate of completion, I don't see Lori's email in the chat room. Sherry, are you able to put your email in the chat room?
And I see a raise hand.
I don't know if the chat is working.
I have some questions. I've received some questions, so I don't.
I don't see any questions in my chat.
I don't know what happened. Maureen says thank you. Did anyone from Brickell Homeowners want to say anything or thank them? I want to thank them as well for assisting in this.
Yeah.
Hi, thank you so much. Thank you for putting this together.
Yeah, thank you, Abby.
Learned a lot.
Yeah.
Thank you.
Abby's with the Brickell Homeowners Association. So that helped bring this together today and reach all of you.
The chat is not working. Just so you know, chat is not up.
Yeah.
So chat's disabled.
Any questions? If you guys want to unmute yourself and ask a question, we got a few minutes. Go ahead.
I think if you put your question in the Q&A, you can.
So I put Q&A. The chat is not working. Did either one of you see it?
No, but I got questions from the Q&A. Like I can see those. If anyone wants in there.
Okay. Do we need to provide? Yes. We get your cam number to us, please. Chat room is presently disabled.
Yeah, the chat disables it. You can put your question into the Q&A, and then Paul and I can see it and answer it from there.
So to contact me, you can do a search on Google for Overton Construction and Consulting. We have a website. I'm very active on LinkedIn. If you're a quick writer, my phone is 407-607-9151, and it's Paul at Overton-construction.com. But it may be easier, www.overtonconstruction.com. It lists all our services and contact information for us.
It's Overton-construction.com. Paul, sorry.
That's okay. Yeah, thank you for the correction. And we do a lot of construction defect stuff, a lot of owner's rep stuff, and we're also do milestone and Sears inspections. Is there a difference between a project manager and an owner's rep? I think you got that one right. Hello, and thank you. Okay, yeah. Yes. Yeah, I disappeared. Sorry about that. My screen still isn't working.
I don't see any other questions. So,
Thank you. Oh, Maureen, how you doing, Maureen? Thanks for joining us. Wonder why the chat was disabled. Who knows? Maybe it's the storm. Well, appreciate everybody showing up. Kara, thank you so much for joining us today. It's been a pleasure as always.
thank you.
And
Thank you for
if you
having.
guys have any questions about your buildings, please feel free to call us up. We do a free consultation. We'll take some pictures. We'll give you a report, and we'll give you our opinion whether you have something or not. It's a free service. You can take advantage of it. And then ultimately, if you decide to file a claim or not, that's really up to you, but we're here to help you.
You guys did a great job.
Thanks,
Thank you.
Jeremy.